The high cost of, if it just saves one life, fallacy. Few phrases end debate faster than this one. If it saves just one life. The statement sounds morally unassailable. Who would oppose a policy that might prevent tragedy? But when slogans replace careful reasoning in the law, something important begins to erode. The phrase, if it saves just one life, operates as a rhetorical shield. It frames any questioning of the policy as indifference to harm. But law cannot function on slogans. It must weigh consequences on both sides of the ledger. Consider what happens when policy focuses primarily on preventing the worst imaginable outcome. The legal system begins shifting from adjudicating evidence to managing risk. Judges become less like referees evaluating proof and more like safety managers trying to prevent the next headline. In family law, that shift is increasingly visible. Proposals expanding concepts like coercive control or psychological maltreatment are often motivated by genuine tragedies. These tragedies deserve serious attention. But translating highly subjective experiences into legal standards creates a difficult problem. Unlike physical violence, which often leaves tangible evidence, many of these concepts depend on narrative interpretation. Identical behavior can appear abusive in one narrative and ordinary in another. Was limiting spending financial control or responsible budgeting? Was monitoring a phone intrusive surveillance or a reaction to suspected infidelity? Was repeated questioning intimidation or concern? When legal standards depend heavily on narrative framing, courts are pushed toward precaution. If the allegation is framed in the language of safety, denying intervention can appear risky. And that is where incentives matter. If a judge restricts parent time or imposes parent time supervision, the decision appears cautious and responsible. If the judge allows normal contact and something later goes wrong, the professional consequences can be severe for that judge. The safest institutional choice becomes obvious. Restrict first, sort out the evidence later. But here's the problem. Eliminating all risk is impossible. The only way to push risk towards zero is to intervene earlier on weaker evidence. And when intervention occurs on weaker evidence, suspicion gradually replaces proof as the trigger for state power. The result can be unintended harm, parents separated from children for long periods, families trapped in prolonged litigation, and trust in the legal system steadily eroding. Protecting children is essential, but protection must remain grounded in disciplined evidence, not fear-driven policy. When the law abandons careful proof in pursuit of absolute safety, it risks undermining the justice it is meant to defend.